represent Chuck Osborne, who's today here in the courtroom. I think this case, first of all, this is a 12C motion, and we do believe there's factual issues that were at issue that were read in favor of North Canton and not in my client. It should have been read in favor of my client. The first issue is, and this is the key to the case, really, the whole case could be disposed over the issue of what Ordinance 2011 actually did. Did it create a water board?
Why isn't that a straight legal call as opposed to a factual? You want to make a factual dispute of it, and I'll be quite honest with you. It seemed to me it calls for us to look at a straight legal analysis of what the ordinance did or did not do.
I guess I'm arguing at minimum, Your Honor. At minimum, there's a factual issue.
Well, explain, because I didn't.
I do believe that it is a straight legal call, and this court should actually dispose of this case on this issue. Ordinance 2011 is attached to the complaint as Exhibit E. It's a council ordinance that amends the water rates. Within that ordinance, what it actually creates is a dispute board. So if you disputed your bill in North Canton, you could go to this dispute board. Nowhere does it create a water board that sets rates. And I want to point out that North Canton says in its brief that this ordinance governs rates and charges. It does not. It's nowhere in here. This board does not.
Rates and charges for water?
For water in the city of North Canton.
And I guess I was left with, had they used the term water board in the title?
No.
Would that have cured your...
Well, that's what I'm trying to point out here, maybe inarticulately. This sets the rates and charges for the city of North Canton.
And that's
the
ordinance?
That's Ordinance 2011. The section that supposedly creates a water board, and that North Canton argues that this section empowers it to set rates and charges, does no such thing. It says, in the event of any dispute as to charges or any dispute as to failure to comply with rules or regulations, the aggrieved party may be referred to a board. This is just a dispute board. That's all it is. And think about this. If this is the water board, then the same board that sets the rates is the same board that causes the, here's the appeals. It doesn't make any sense. So it's an appeals board and it's a water board. It sets the rates and here's the appeals and the rates. Doesn't make any sense at all. And that's not what this ordinance does. And this court can take care of this case by analyzing this. This ordinance is clear as day. It doesn't, the plain language of it does not create a water board.
Well, is it a factual dispute or a legal dispute?
Well, at the very least, it's a factual dispute. At the minimum.
Saying it doesn't make it true. I keep hearing you say that, but it seems everything you're arguing is straightforward in this ordinance, and whether or not we may agree or disagree with your interpretation of it, but I can't get beyond, and the point is, I can't find a factual dispute on this. I'm having trouble.
I'm sorry. I guess I'm.
When you say at the very least, I'm saying I can't even see the least. So
the factual dispute is we claim this does not create a water board, which we believe we can flesh out in discovery by how it operates, what it does, that it doesn't create any rates, it does none of the functions of a water board. That's what we could do factually. We don't think we really need to do that because if you look at it, it's clearly not creating a water board. So we think the legal issue is clear.
All these other things you tell me what you'll do in the hearing, that could create a factual dispute, but that's not changing anything about what we're looking at on the complaint for a 12C.
Thank you, Your Honor. I'm just arguing under the 12C factual issue. We do think the legal issue is clear. Then we move forward to the next ordinance that was passed in 2017. It's the first time water board shows up in North Canton's ordinances, but it doesn't create any membership. It doesn't do what a water board does, and we believe that also is in violation of Revised Code 74304A, which mandates that the Director of Public Service or any other official or body authorized by charter may assess and collect a water charge. So, the state code sets out how this works for water charges. The service director is the default, whether you're a charter city or non-charter city. If you become a charter city, you have an option. If your charter allows for a body or an official to assess and collect water rents or charges, then you can create that power within that, you can assign that power from the council to that body or official. But otherwise, you can't. The authorization by charter that North Canton relies on is simply that they can create boards and officials in the first place.
That's section 3.03 of the charter.
I don't have it in front of me, I believe that's correct, Your Honor. So, but
That gives, the charter gives them the authority to set departments, division, boards, commissions, officers, and employees as they deem necessary, and to determine their duties. So they have the capability to create a quote water board, correct?
Sure. Okay. Well, no, they have, charter does not give them the authority to create a board to assess and collect water rents or charges. They need to change the charter, allowing that power to be assigned, because right now, it should be either with the council or the service director. They have to make a charter change to do that. This is a.
So you're saying anytime they create a board, as they're allowed to do in the language I just read you, that's what it seems pretty clear they can create these boards. They have to give a special designation at that time as to what that board's duties will be.
Well,
Would that then satisfy, in your opinion, RC 74304A?
if they created a board to assess water rates, water rents or charges. And
That's
the
what I'm saying,
charter
they have
allowed
to
them do that.
specifically designate what the board's authorized to do. You're saying that has to be in the original creation of the board.
Of course, North Canton can create all.
I was hoping you were gonna say yes or no.
This is a special area. That's where the confusion, I think, is coming in, because the state has stepped in. The state has said there's a way this has to be done. Your charter has to allow this to happen, for this to happen this way. Council can't willy-nilly do it. Throw in the issue that this is an extraterritorial impact. The 2017 ordinance is specifically setting rents and charges extraterritorially, so it's not even a home rule issue like North Canton argues, it's extraterritorial. So even more so, they come under the state code, which requires the charter to name, this is the official that can can assess water rates. This is the kind of board that can assess water rates. That's how that has to happen. It's not in the normal creation of boards and commissions that cities do every day. It's special. And it's special because it involves fundamental issues of sewer and water. I'm sorry, I reserved 5 minutes, so I.
Go ahead.
Yeah, but back to the question, are you saying that the ordinance 2011 has to name the water board, its members, and its duties? I think that was Judge Hoffman's question.
There's two ordinances, so I don't want to confuse the two ordinances.
Okay, go ahead.
The 2011 ordinance sets up an appeals board, period. That's all it does. This court should rule on that and resolve this case. The second ordinance sets up a water board, but then it doesn't name anybody to the water board. And even that ordinance is not enough because the charter doesn't authorize it. I would argue that. I don't think we even have to get there though. The simple resolution is the 2011 ordinance. But even the ordinance in 2017 is not enough. It's not done properly. It doesn't name a board. It's the first time ordinances say water board, but doesn't name any members, and it doesn't follow the state code. They've got to follow the state code because these are fundamental issues of sewage and water. There's a way the state legislature wants us to do, and beyond that, the 2017 ordinance is extraterritorial, so it does involve a home rule issue.
let's hear from Anthony.
May it please the court, Mr. Mendenhall, Greg Beck on behalf of the city of North Canton. First of all, let me just say that there is no disputed issue of fact in this case. It wasn't raised below, and I agree with the court that this is merely a question of law based upon the statutory scheme.
I haven't reached that conclusion,
All right.
but I'm just trying to understand the argument.
But I do agree with the general principle, and I think even Judge Hartman below made that conclusion because it wasn't raised below. I do not believe there's any disputed issue of fact. What we're dealing with, Your Honors, are one statute, which I'll call the enabling statute, that's 743.04. That provides information on how a municipality may regulate water rates. And when you look at that particular statute, it basically says that the municipality has several options as to who would be in control of assessing those water rates. And my colleague keeps suggesting that this has to do with sanitary information and so forth. That's not true. 743.04 deals with the issue with respect to water works and water. And it says that the Director of Public Service or any other city official or body authorized by charter. So that enabling legislation allows council to designate a board through the charter, as long as the charter in fact allows that. Then we move to 3.03. 3.03 says that the council may create various boards, and in this situation, it says that a board as it may deem necessary to determine the organization and duties of each officer or employee. So, as the court noted below, the first process is you look at the enabling legislation, then you look at the charter. The charter under 3.03 gives that power to council to decide whether or not it's going to create an authorized body, which it has the power to do. Then we move to 2011 Ordinance 20-11. That particular ordinance dealt with water rates. What was happening in 2011 was the city of North Canton wanted to more firmly establish its water rates. And so within the context of that ordinance, which was an amendment to 937 of the codified ordinances. And that,
Slow down.
I'm sorry, Your Honor.
We're now at 2011, and I'm looking at 937.03D.
Yes, and that's it. But I was stepping back a little bit from that to say that that whole ordinance, that amendment to the ordinance was dealing with water rates in general. And then when you get to 937.03D, they create a board at that point. And it was very specific about this board. It was the law director, it was the finance director, and it was the director of administration. And that board was there to handle all disputes with respect to water rates.
But they didn't actually set the rates. The rates are actually set in the ordinance itself.
That's true. That's true.
And doesn't the ordinance, then that ordinance also does provide for the auditor to do the collection of any delinquent bills?
Right, and this particular board, as delineated with a capital B, is to then regulate any disputes with respect to any aspect of these rates, payments, collections,
Okay,
and so forth.
so you have this review board. It's a review board to resolve disputes.
Right, we have a board that was established
So,
to,
and then you change the duties of that board in the 88-2017 ordinance.
certainly,
Okay.
which we're entitled to do. I mean, again,
Right,
if you go back to 3.03, we're allowed to determine, if we establish a board, we're allowed to set it forth its duties and responsibilities. In 2011, those responsibilities were to handle any dispute arising out of the rating system. Then in 2006, years go by, and now all of a sudden, we're looking at a separate issue. And this issue deals with how do we handle issues with respect to water transfer or even maybe sanitary transfer to a non-resident. And so the council decided to create a liaison between the water board that it established in 2011 and the chairperson of the water, sewer, and rubbish committee. And that would be the contact and the decision makers with respect to how any rating and water would be accessed by a non-resident.
Because the 2011 ordinance only deals with rates for residents.
Correct. Now, what council did in 2017 was take that same board and expand its responsibilities and duties. And that's our premise. And so I think my colleague seems to suggest that if we would have just said water board in 2011, that would have sort of resolved the issue. But I think that's unnecessary because the board that was established at that point was dealing with water and the use of water, which falls completely within the ambit of 743.03A, the enabling legislation that they're now trying to say prevents us from doing what we did in 2017. So I think it's really getting down to semantics. But in truth,
Does 88-2017 amend that provision, that specific provision?
it does not amend the 2011 ordinance, because it's a separate section. That section was, and I know it's confusing, and I apologize, 937 was the ordinance that was addressed in 2011 with 20-2011.
Okay,
It's
so
935.
20-20-2000?
20-2011, so it's literally ordinance in 2000,
Got it.
20th ordinance in 2011. That addressed section 937, which dealt specifically with rates.
okay.
In 2017, 88-2017 dealt with 935. And that,
Oh, okay, I see.
that's
Thank
the
you,
difference.
thank you. I
and
got
so,
it.
and I
Okay.
apologize for that confusion, because these numbers are running.
I wanna go back, because you're saying 20,
This is the second one, 88-2017.
and you're saying that dealt with 935,
35, right.
whereas
935.
2011 dealt with 937.
Correct. And
Where,
there's,
I wanna see 935, where do I, is it in the briefs? Thank you, Judge Weiss.
Yes, yes, and that is the water rates, which is 935. Our 935 deals, is the amended portion, and it was actually 935.08. And that dealt with changes in how to handle the extension of water to non-residents. And it empowered then the water board, as it had already been constituted, to work with the committee chair to handle those particular situations. My position, Your Honor, is that the trial court actually made the right choice. It followed this logical progression that I've been talking about now. Legislation through 3.03 down to these particular ordinances. But then the court went a step further and said, even if we did a home rule analysis, there's no conflict between the core purpose of this particular statute, 743.04, is to set forth a process so you can fairly assess rates. That's the idea. That's the whole concept that's being proposed here, which is why the trial court said that these things aren't even in conflict. In fact, they're in harmony.
Okay, help me understand. As I read through the entry, I know we get to this section on home rule, and the discussion are these compatible. Is that a separate basis to support the trial court's decision? What I'm looking at is the two-issue rule. Because I didn't see, as I read appellant's brief, a specific challenge as to the discussion the trial court gives on that home rule. Is that a separate independent basis to support the trial court's decision?
It is, Your Honor, because that's what the trial court did. The court said, even if you think there's some confusion with respect to this structure, let's look at the real purpose here. It's a charter city, it's home rule. So if the creation of this ordinance was in fact somehow inconsistent with that enabling legislation, we need to look at that. And that was what the court properly found, and of course this wasn't a general rule, it may have been police power.
Okay, I'm trying to boil this down into simple terms, because I feel like I'm being waterboarded myself.
And I apologize.
Your suggestion is, do I hear you, if somehow the 2011 was not a properly constituted water board under section 303 of the city, that independent of that, the home rule provisions would give it a independent source of authority to create that ordinance.
Correct.
And that, okay, that answers my question.
Thank you. In fact, if there are any other questions, I would ask the court to affirm the decision of the trial court. Thank you.
Thank you. Okay, rebuttal?
And
know I was all over the place, but let me go back to the extraterritoriality. Because it's extraterritorial, the home rule does not apply.
I know in that analysis, because it isn't developed much in the briefs, is that a statewide issue? I mean, because if we're talking about a designated portion of residents outside the city, is that, it doesn't seem to me to or have statewide impact, which is one of the factors, if I understand correctly, you look to whether or not it's a valid exercise of home rule.
I disagree with that.
I'm not saying I'm saying
don't-
that affirmatively, that's what I'm trying to understand.
The statewide issue is that the municipalities and the local governments are treated the same under the state statutes. It's not whether, this one goes out extraterritorially here, this one goes out extraterritorially there, and there's separate analysis for that. It's a statewide issue in the sense that the state legislature has said, this is how we're treating water and sewer issues, especially when they're extraterritorial.
Is there a conflict between the ordinance and the statute?
Yes.
What is the conflict? Because I think the trial court said they were not in conflict.
Well, which ordinance are we talking about? They're both,
I'm not sure, I want to go back to the judgment.
I think there's a conflict with both ordinances, is what I would say. And the conflict
Well,
is-
give me the 303, I'm sorry, 2011 conflict.
The 2011 conflict, well, I mean, there's no conflict there because we don't believe it created a water board. It's an
Okay,
appeal- it's an
assume we
appeals board.
disagree with you,
For
just for the sake of this question. Say we deem it to have created a water board, is that in conflict?
Yes.
With, how is it in conflict?
It's in conflict because the charter itself, 303, which you were referring to, that charter itself needs to be amended to say that they can deal with water rates through a board. And that council, just like it says here, council by ordinance shall provide for a finance department, a law department, and a water and sewer department. That's how they would deal with it, or a board to govern sewer and water rates. That's how you deal with it. It's a simple charter change, couple of words. But they need to make that charter change before they can create that ordinance. They can't that's what the state code requires. You can't read that out of the state code, which is what North Canton wants to do.
And what the trial court did.
And which the trial court did.
Disagrees with your interpretation of the state statute.
Right. So, 2011, we don't think does anything, and that's fine within the context of having an appeal of your bill. But 2017, the ordinance 2017, does a whole lot. And it takes the authority away from the service director.
Would it be in conflict?
Yes, absolutely.
How is it in conflict?
Same reason. The council the charter, which is created by the citizens, did not give the power to the council to shove its power off onto a board like this. It just isn't in the charter.
You want the current system with the service director determining the rates or council determining the rates to apply to non-residents and not have the water board, this separate entity, determine those rates. Okay.
And part of that is because of the accountability. The way they're doing it is they're doing it through the council. You've got full accountability. The citizens can come in, people can come in. When you have that board, you lose that accountability. But North Canton can lose that accountability if it wants to. It just needs to go to its voters and ask for the power to be put into its charter. It's a few words. They don't want to do that, apparently. That's the easy way to do it. But the problem is citizens may not agree with that power. They may want more accountability.
Who does it in the absence of a designation by?
Service directors the default.
Well, it says,
Service.
I'm looking at it, it says Director of Public Service or any other city official or body authorized by charter.
Mhm.
I'm not sure there is a default provision in the, if they haven't designated anyone, I'm trying to make sense of the statute, but it seems to me they have to either designate the Director of Public Service or some other city official or a board, body.
Right.
In the
Director-
absence of doing so, no one has the authority to
No.
do this.
Your
Yes, sir.
Honor, the Director of Public Service has the power, period.
But
Or,
I'm looking,
or any other official
Oh,
or
okay.
body authorized by charter. You know, I mean, you can put some commas in there and change what it
okay,
means,
I
but
see your point.
the official or body
I
has
see.
to be authorized by
I
charter.
see your point.
So charter we can get that in the charter.
Okay,
Thank you.
thank you, counsel. Matter has been submitted, you'll be advised in writing once we reach the decision. The last case